Justice Thomas, anything further? Justice Alito? Justice Sotomayor?
We are being put to two extremes here. The other side says there's no liability because we're just putting out into the stream of commerce a good that can be used for good or bad, and we're not responsible for the infringer's decision. We have the other side, which you're moving away from petitioners and the SG's position, that the only way you can have aiding and abetting in this field is if you have purpose, all right? And you're saying we don't have to prove purpose, we have to prove only intent, correct? That's the other extreme. But what Justice Alito said, and some of this is that the internet is so amorphous, and what it can or cannot do, I'm not sure about. We're being told that ISPs only know who their customer is, and their customer could be a region. And if it's a region, to say that because one person in that region continues to infringe, that the ISP is materially supporting that infringement because it's not cutting off the internet for the 50,000 or 100,000 people who are represented by that customer, there is a feeling of, how can I say there's a purpose to participate in that situation? Whereas I could see a purpose on single-family homes, because they're usually limited by the number of people, and one could say, if you know that it's one or two or a family of 5 or whatever number it is, it's small, that surely I'm materially contributing there. How do we announce a rule that deals with those two extremes?
So, I mean, you know, my frontline answer would be I think the safe harbor takes care of the regional ISPs. And frankly, I'm not that worried about the regional ISPs, because if that were really the problem, we could go after the regional ISP.
You told me that there were 95% of the infringements here were of residents, so you could go after those 95%.
Right, and we could probably figure out who the regional ISP is and then go after its customers. That's why I'm not going to die on the hill of the regional ISPs. And I think you could, I mean, you know, material support, I mean, you know, heaven knows this court remembers from Twitter that, you know, by the time you look at the common law, you had 6 factors under Halberstam for what is substantial assistance. So there's clearly enough sort of, if you want to, if that's the hypo that's concerning you, then you can certainly sort of come up with a definition of material contribution that carves that out. I think
give it to me.
What's that?
Give it to me. I'm inviting you to help me.
And I'm inviting you to take my help. I mean, I don't want to, like, you know, it's hard to just absolutely give it away in a case where that's not the way the case was litigated. But I am telling you that, you know, my friend I thought was remarkably candid in admitting that if you adopt their position, that really is an extreme position. The DMCA and the safe harbors are dead letter. If you carve out regional ISPs, the safe harbor is alive and well, and equally importantly, the incentives for both sides to come and to try to have a reasonable negotiation are alive and well.